Yes, by now, with a short resume, I tried to give an introductory uh, lecture regarding the law of bankruptcy and tried to let you know about the historical background, the nature of the law itself, and also the methodology, purpose and object of this particular law, the law of bankruptcy. Now, I also discussed the whole drama to give you an idea at the very outset actually what happens under the law of bankruptcy. Now I will go topic wise, and it is suggested that you keep your book 2 in front of you while you listen my lecture so that you can refer the important topics and find them out in your handbook which I have already delivered to you. Number 1, question may arise then, who is a bankrupt? As I told you, somebody who don't have enough cash liquidity in his hand and finds it difficult to pay the creditors. Now, such a person, the law requires, must commit an act of bankruptcy under Section 9 of the Bankruptcy Act 1997, the new law of bankruptcy. Section 9, you will find them in page 10 of your handbook. In page 10, categorically there are 9 different clauses under Section 9. If any of them is done by the person, it will be considered that he has committed an act of bankruptcy. And if you look to them, there are as many as 9, and it's important for you because if the question comes, who is a bankrupt? So a bankrupt must commit an act of bankruptcy, and what will constitute an act of bankruptcy? Either of the 9. Number 1. So if a person started substantially selling all his property in Bangladesh, then it is an act of bankruptcy. The creditor goes to him and say, please pay us, and he said, I don't have any money. But then again, the record shows that in last 1 month he sold 2 of his properties. So this is an indication that this man is out of financial stability, so he is selling his properties. Number 1. Number 2, transfer of property with the intent to defeat or delay the payment to the creditors. If a person with the intention not to pay the creditor and sell his property or transfer the property in the name of his friends, a distant relative, these are known as delaying not to pay the creditors, and it is also an act of bankruptcy. The third reason is that if the transfer, any of the transfer of a person, a person who cannot pay his creditor, will be considered as fraudulent transfer. He transferred the property with a fraudulent intention. Now, what is fraudulent preference or fraudulent transfer? If a debtor, while disposing his property, do not give equal preference to all his creditors, but prefer to give preference to some of his creditors, ignoring the others, that preference will be considered as fraudulent preference, and that is an act of bankruptcy. Supposing I am in a difficult situation and about to become a bankrupt, but still not declared bankrupt, sold my second-hand car for 10 lakhs. And what I have done, I decided to keep 3 lakhs for my personal use, and I divided the 7 lakhs among 3-4 of my very liked students whom I like, who are good students They also, I owe them money also. So in such a situation, I called them, please visit me in my office, and I distributed that 7 lakhs among my 4 very good meritorious students whom I like, not delivering or dividing the whole 10 lakhs taka or the 7 lakhs taka to all my creditors. This is known as a preference, which is a fraudulent preference. What I should have done, I should have distributed this available money to among all my creditors. So instead of doing that, I have given a preference to some of my students. This is known as fraudulent preference, and this is an act of bankruptcy. Number 4, if with the intent to defeat the creditors, I remain away, departs from Bangladesh, do not attend my office, not available in the house, even 6 o'clock in the morning, or even 11 or 10 o'clock, 12 o'clock in the mid of the night, I am not available. That means I am trying to avoid my creditors. I am fleeing around. So this is an act of bankruptcy. Supposing that due to my bankrupt situation, somebody filed a civil case against me for money, and he procured an order from the court for execution of my property, and naturally the court official sold my property in execution. That is an act of bankruptcy. Again, suppose I personally went to the bankruptcy court and filed an application that I should be declared as a bankrupt. So this is an act of bankruptcy. The court takes it granted that unless I am in a situation that I cannot pay, why should I come before the court and say, please declare me as a bankrupt? So this is an act of bankruptcy. Suppose I notify all my creditors to whom I owe money, notifying them that from the month of April or from the month of May to 2020, I will not be able to pay them because my financial position is bad and I am broke. This piece of communication from my part to them, or this letter, is an act of bankruptcy. If I am imprisoned for not being able to pay money under any law, that is an act of bankruptcy. And the last one is that if there are persons to whom I owe money and there is a debt of, say, several thousand takas, these creditors, before go to the bankruptcy court, file an application for making me as a bankrupt, they need to do something. They will ask me a notice of demand, serving a notice of demand, and ask me to pay the money within a particular time. They will specify a date that if you do not pay our money within that particular specified date, then we will be constrained to go to the bankruptcy court. From that day onwards, the date which is mentioned in the notice, a day will be mentioned. That day will be the last date, but the persons who send the notice cannot proceed to the bankruptcy, and they will further wait for a period of 90 days. That means 3 months. And once the 3 months is over, then under the law I commit an act of bankruptcy. For example, 3 creditors has a claim of 50 lakhs. They will give me a notice saying that please pay us by within 15th of April 2020, failing which we will go to the court. And supposing I could not pay in by end of the April 2020, but they cannot immediately go to the court, bankruptcy court, and file an application. What they will have to do, they will have to wait 3 months. So after April, May, June, July. By the end of the July, their right to file an application against the bankruptcy court will be ripened, and I will be considered to commit an act of bankruptcy. So these are the 9 different things that you must keep in your mind. Easy way to know who has committed an act of bankruptcy. Legal requirement. Now, question may arise, who can apply for a bankruptcy? Against who? The creditor can always apply for declaring the debtor as a bankrupt. Only thing is required that it should comply with the Bankruptcy Act 1997. The debtor himself can apply. He himself can go to the court and say, please declare me as a bankrupt, because I am not in a position to pay my creditors. And in such a case, the things become very easy for the bankruptcy court, because if the thief himself said that I am a thief, there is nothing to be done. No proof is required, because he is saying himself that he is unable to pay. So under these circumstances, both the creditor and the debtor, they can go to the bankruptcy court, and accordingly the bankruptcy court will take the necessary steps. As previously I told you, the total drama actually what happens. So after section 9, another 2 sections are very important for you, or other the 2 provisions of the 2 sections, like section 12 and section 13 of the Bankruptcy Act 1997. Section 12 talks about when the creditor can apply to the bankruptcy court. Section 13 prescribes the mode and method when the debtor himself can apply. And for these 2 topics, please refer page 10 and page 11 of your handbook. Page 10, please, page 10 and 11 of your handbook, where it is categorically mentioned when creditor can apply and when the debtor can apply. Section 12 refers to the right of the creditor, that when a creditor can apply. And section 12 provides 3 conditions, as you have seen in my handout, that any debtor or 2 or more debtors having a claim of minimum 5 lakhs taka in one way. That means if 3 creditor is applying under one application, their total claim against the debtor should be 15 lakhs taka, nothing less. This is number 1. Second condition that the creditor must fulfill, that the creditor must have a prima facie case that the debtor has committed an act of bankruptcy. Now, what does prima facie mean? Prima facie is a Latin word, it's not an English word. It means that on the face of it, you have to show before the court something. By looking into it, the court will be satisfied that yes, Mr. Shamsuddin Mahmood has committed a bankruptcy, because some documents that reflects prima facie on the face of it, what can be, supposing a bounce check prima facie shows that this gentleman is not being able to pay, or a letter from a particular person where he is saying that from the month of April 2020 I will not be able to pay any money. This is a prima facie evidence. I mean, in other words, any 9 of the requirements under section 9 of bankruptcy, you have to prove before the court. In the last section 9, which was the important section, we discussed about 9 different things. You have to show before the court that any of the 9 elements, any one of them is present to make the court prima facie at the initial stage